The question is not whether international law is legitimate. Of course, it's legitimate in its own realm. The real issue is the overly romanticized view many hold about its efficacy, its application, and particularly its relevance to the American legal system. It's like expecting a sonnet to do the work of a sledgehammer. Poetic, perhaps, but hardly practical. Let's start with the very nature of international law. It's a body of rules, norms, and standards that govern the relationships between nations. And in theory, it sounds splendid. But when we descend from the ethereal heights of theory to the solid ground of reality, we find a patchwork quilt of agreements, treaties, and customary practices that vary wildly in their enforcement and effectiveness. In short, international law often lacks the teeth to back up its bark. One of the great illusions about international law is that it operates with the same precision and authority as domestic law. But let's not delude ourselves. International law lacks a central authority with the power to enforce its mandates. The United Nations, a noble endeavor perhaps, but not exactly a paragon of swift and decisive action. The International Court of Justice, an august body, no doubt, but its judgments are more persuasive than compulsory. In international law, enforcement often comes down to the whims and wills of sovereign nations, and history has shown us that these can be as fickle as they are varied. Now, as to its application in the United States, particularly in our courts, I have been quite vocal. To those who would look to international law as a guiding star for American jurisprudence, I say, be wary of losing your bearings. The Constitution and the laws of the United States are our supreme law of the land, and rightly so. To subordinate them to international norms is not only legally dubious, but also philosophically unsound. In the realm of human rights, for instance, there is a tendency among some to treat international agreements as if they were holy writ. But let us remember that the rights enshrined in our Constitution were forged in the crucible of American history and thought, not in the salons of Geneva or the halls of the United Nations. Our Bill of Rights is not a mere reflection of international consensus, but a document born of our own unique experience and struggle. While international law has its role in the global theater, it must not be mistaken for a panacea. It is not the ultimate arbiter of justice, nor should it be the yardstick by which we measure our own laws. The United States is a sovereign nation with a legal system rooted in its own soil, and while we can and should engage with the world, we must do so with our eyes wide open, fully aware of the strengths and limitations of international law. To do otherwise would be to wander blindly into a legal and philosophical morass from which our Constitution provides the only sure footing.